So let me get this right, Josh. He was out on bond for the aggravated robbery. He was out on bond on the other case, on the retaliation, and then he picked up these two new cases, right? Is that right?
Let me check that.
I think he was out on bond for the ag rob, and then,
Oh, the
Picked up.
ag rob's from May.
yes. And then picked up
Picked up a
that.
retaliation on 9/4. And then after that, so it's a third time he's out, and then he picks up another case?
These allegations, Judge, are from August of this year. The two cases in this court.
Yes.
Let me see.
It was after the ag rob and before the retaliation.
All right, so the retaliation is September 3rd. Mischief is August 28th. Theft is August 8th, 28th as well. Officers get a call that a robbery has occurred. Complainant stated to officers, two defendants later identified as defendant Marshall and defendant Ronald Waters, which was our other defendant from the other day, right? Remember Ronald Waters from yesterday? Hereinafter referred to as Waters and Marshall walked into a store, destroyed a glass partition which was $300 to replace, and walked out of the store with 3 vapes and other stuff. Sodas and complainant stated both defendants walked in at the same time. Waters came up to the counter stating he wanted to purchase a t-shirt located behind the counter. While that was happening, Marshall attempted to come behind the counter, but the complainant was able to stop him. He reported that Marshall then came around to the front of the counter where Waters was. That he was distracted by Waters, who purchased a t-shirt, opened the packaged shirt, and seconds later wanted a refund, which he gave him the refund. Complainant reported that as that was happening, Marshall used his hands to mess with the glass partition, heard the glass breaking, grabbed 3 vape pens, other things, and ran out the store without any attempt to pay. Complainant states that he knows both defendants by sight and can identify them from priors. So while being out on all that, on the aggravated robbery, in that one, what do we have? Did he hold someone up?
The ag rob.
Yeah, let's see how dangerous Mr. Marshall really is. Allegedly.
So the complaining witness was a delivery man for Domino's. I believe he made a delivery to the co-defendant in that case. The complaining witness said he felt something wasn't right and told the co-defendant to just pay him half so he could leave. The co-defendant pulled out a handgun, pointed it at the complaining witness, and demanded the pizza. The complaining witness noticed this defendant by his vehicle at that point and observed defendant Marshall open his front passenger door, reach in and steal a fanny pack that held his cell phone. So this defendant
Part of
was,
the offense. He's not the one with the actual.
he was not the one pointing the gun, yes, Judge.
The complainant began to feel that something was not right and offered to accept half the amount due for the pizza just so that he could leave the location. White then pulled out a firearm, pointed at the complainant, and demanded the pizza. White told complainant that he had 5 seconds to give him everything he had and began to count out loud. Do you know how scary that is to have someone hold a gun at you, tell them you have 5 seconds to give them everything or else? That is really, really terrifying and can cause people to have nightmares, all kinds of psychological issues. God. When defendant White reached his 5-second countdown, the complainant stated that he saw defendant White attempting to pull the trigger and could hear a clicking sound. It was at that moment the complaining was fearing for his life. He attempted to push defendant White's pistol away from his face and was able to retrieve his own firearm, namely a pistol. Complainant feared for his life and discharged the pistol at defendant White. Oh, the complainant shot and killed defendant White, who died at the scene. Complainant stated the defendant Marshall ran off with his property and the complainant drove to a safe location before calling the police. This is Houston. I will do everything in my power to protect our city. And I want you to understand that. And that person is now gone. For a pizza, his life is now gone. How well did you know this person? How well did you, was he a good friend of yours?
Someone I knew in the apartments.
I'm going to make each of your bonds $3,500. Mr. Marshall, I want you to understand that if you are able to make bond, I'm putting a whole host of conditions on you.
Sir, I will understand.
Don't be a danger to our city. You have but one life. Stop. You have but one life. You know, when it's gone forever. And it's so very, very short. So heed the advice, because I'm not giving you any more warnings. Do you understand? Okay. Thanks, Steve. Thank you. Good morning, Mr. Jones.
Good morning.
Mr. Jones, you were wanted out of the state of wherever. Probably denial, I don't know. But I have you here now because your lawyer is asking me to set you a bond.
Yes, sir.
I don't know. I've never met you before. I don't know who you
Order in the
are.
court.
No, my primary concern are two things. Number one, will you go back to the jurisdiction that you wanted from? Number one.
Yes, sir.
More importantly, and most importantly, are you a danger to the community? I know that you're going to tell me that you're not. Everyone says that, right? But what really dictates is how you look on paper, because that tells me who you really are. So I just don't know. We'll go through all that and we'll determine whether, you know, I do know that you have an open evading arrest in a motor vehicle. So you're now charged with a 3rd-degree felony. And so, all right, Amy, tell me about it.
Yeah, he's wanted from St. Lucie County in Florida.
Florida. Oh,
Yeah.
ouch.
He's wanted for a violation of probation for grand theft of a motor vehicle. We're asking for no bond at this time. For one thing, he picked up this evading of a motor vehicle while on that probation. He has,
Is this a stolen car too? Allegedly.
I don't think he was charged with that, Judge, so I would say,
Yeah, I mean,
a prohibited vehicle on the toll.
but we had an earlier case today, same thing, in a stolen car, right? Allegedly, and they didn't charge him with the UUV, but they
Really?
could have.
okay.
So it's intake, I don't know, just these days, it's,
I'm seeing prohibited vehicle on the toll. That's
so
all.
it is a prohibited vehicle?
On the toll.
So
I don't know.
a
What-
prohibited vehicle could be a vehicle that
Yeah, it's
has
very,
outstanding
very vague.
balance. That's exactly right. Or no tags or,
What other kind of criminal history he got?
Yeah, he has an obscene number of fraud and forgery charges out of Florida and Georgia.
How many?
22 pages worth.
22 pages worth of criminal history?
Yes, he also has
Whoa!
several failure to appears out of Florida. He was arrested in May 3rd of 2023 for a probation violation in Florida. Of course, this probation violation is for 3 different violations for failure to report and then changing address without permission, I think.
22 pages of priors.
well, I would say this, Judge, sometimes the one case can take up to 2 pages sometimes, so
Even by that theory.
even, I get cheaper.
He also has misdemeanor and felony willful obstruction of law enforcement officers out of Georgia.
I'm surprised you even got probation. You know, I mean, really, it's, you know,
All the charges were trickled down to 2 counts. So there was, all those charges are the exact same charge, and they dropped it to,
22 pages worth of the exact same charge?
it was 19 charges. and they brought it down to 2. They was basically 2 charges, 2 different kind of charges, but 9 charges of each. So
It happened that would garner 19 charges. That's usually something where you have like a mass event, like a shooting or like,
The probation violation's original charge, which was a grand theft of a motor vehicle, he obtained that motor vehicle by,
like false
buying it.
pretenses or something.
Yeah, he tried to buy it with a false pay stub for a false company.
Judge, if I may,
Sure.
Judge, I'm not asking for a PR bond. I'm asking for, even if you consider a bond, a high bond amount that would allow him to go turn himself in. He would have skin in the game. It's a monetary sum that would ensure that he goes and turns himself in. He hasn't messed up in your court before.
Seen.
I'm sorry. And so it would allow him to at least go present himself while also understanding the risk of losing a big deal of money. So I'd say that.
Whose money? Not his money. What kind of money you got? Doing what?
You know, I'd like to afford him the opportunity to post that bond, if you entertain.
Well, the first thing I'd need to know is, out of the 22 pages, what are all those, I'd like a list of like every single charge that he's ever had.
Okay.
I'd like to know the disposition of those charges.
Okay.
Because, you know, the problem is, Mr. Jones, is that when you have too much baggage, the more baggage you have, the higher of a flight risk you are, because you know that at some point you're going to have to answer to those charges, and you're going to try to.
But I answer to all those charges.
Well, I don't know that. I know you're telling me that,
I
but
understand, but those, I handled that. That was my first real case, and I handled it.
yeah, I mean,
And some of those with like the FTA and stuff, I turned myself in. It was misunderstandings with court dates and stuff like that. And it will show where I turned myself in like multiple times.
Oh, pause for a second. Did you catch that? The defendant is claiming all those missed court dates were misunderstandings. With 22 pages of criminal history, misunderstandings start to look a lot more like patterns. Question for you watching. Do you think the court should give someone with this kind of record the benefit of the doubt, or is the judge being fair here? Drop your take below.
in this case here, you're trying to evade capture here. I mean, so I don't know. You know, I need to know a lot more about you before I were to grant you a bond, you know?
Like the current case, I can't speak on that right now. But
Don't.
all the other cases, I turned myself in and I handled what I needed to handle.
You know, has he ever had a prior fugitive case before? Out of where? So Ricardo, if you want, we can do a deeper dive, or you guys can do a deeper dive and let me know more about him.
Here's the thing, Judge, I don't think it's, here's how this it would work. I don't have access to the 22 pages. I would love to give you the report by tomorrow. I can do that.
So what we can do is we can ask Amy to print you out the NCIC report. Can you provide him with a copy?
I'd have to stay.
This moment is huge legally. When a judge talks about baggage and flight risk, they're not being dramatic. They're talking about the core of bond law. Judges don't set bond based on vibes. They look at risk. Will you come back to court or disappear like a ghost in the system? With 22 pages of priors, this man isn't just carrying baggage, he's basically bringing a U-Haul.
It's all right with you, Judge.
They're, at least at the minimum, I know that they'll let you look at the report. So you can look at it and write it down. I don't know if they'll give you a copy of it, but at least you can look at it and we can try to work through to see all the charges of what they are.
Right.
Try to find out what the disposition, but,
I can also go through it and.
right.
Okay.
But with 22 pages of prior criminal history, I'm going to tell you now, it's a really uphill battle to get you a bond. And if I do.
Okay, here's the hook. The judge is talking 5 digits, maybe 6 for bond. That's life-changing money. And with Florida in a hurricane emergency, the court is extra suspicious. It's like the perfect storm, literally. If you were the judge, would you set bond at all? Or keep him locked in until Florida picks him up? Tell me what you would do.
Give you a bond, it's going to be a hell of a high amount now. In the high 5 digits perhaps 6 digits because, no, I want to make sure that you turn yourself in. And the problem is that I know that there's a hurricane out there hitting Florida. So it's a perfect time for you to give me this kind of excuse there. I couldn't make it there. I couldn't make it here because of this and that. And when here,
Okay, okay, I'll explain to him his options, Judge. We'll go over where we're at and, I'll see how he wants to proceed.
okay, but I'm going to tell you now, if I were to give you a bond, it's going to be in the high 5 digits.
Understood. Judge, my understanding is he already waived on, October 8th, and so his, pickup date is.
You know what? And I'm going to tell you now, we have at least 3 other people here from Florida. And I think it's Miami-Dade, right? Wasn't it Miami-Dade that we have?
This one is St. Lucie County.
How far is that from Miami-Dade? So perhaps we can come get them to pick you up in addition to those 2, because I know that we have at least 2 transports that are coming here to pick up another 3 individuals from Florida. So maybe we can get you on that, and they're supposed to be here next week. You know, so if you waive, or look, like, I mean, you've already waived,
Already waived.
so great. So
I'm not trying to run from nothing. I just want to get this over with.
here's the only other advice I'm going to give you now is that you need, if you do go back, you have to stay in contact with your felony lawyer in your felony case, because if you don't, and they think that you've absconded, they're going to issue a warrant in that case. And then the hold that you have here for your Florida stuff, it's going to happen to you over here, because you're going to be over there, and then you're going to get a Harris County hold. So when you do finish up over there, you're not going to get out, and they're going to try to transport you back over here. That is Eileen Bogart is your lawyer over there. So just stay in touch with her to let her know what's going on, and that way they don't overlook you. But okay,
Thank you, Judge.
of course.
I'll go ahead, my client.
Judge Moore.